Is the weather gonna hold?
You probably have so many kid things all the time.
You are in the thick of it, Ryan. We might have. Board games tomorrow.
Go to. I watched my brother's kids for a week and I was driving them to different lessons, 100% of the time. So this is why we're connected. How many lessons do you guys need?
Michael,
Yeah.
I gave Christine
And they're all of it.
Service Pro, so if she needs to hook into the system, she can.
Can't do it from up there.
Oh, she can't?
I'm gonna have to do
Until
it.
it's on their own.
Okay, well, she has a
I'm
connector
taking
now.
the lessons.
See you tomorrow, got
Right.
The HDMI cord
got 4 games tomorrow.
of mine, and I use the Service Pro, so it worked out good.
You get anything done,
I don't do anything.
anything that you,
I take a day off of work and just leave. Nobody knows, I go off the company, just like, I'm going to work and just go do it.
it seems so hard on you. Are your kids like athletic? More about like having things like it. I mean, my dad told us. I'm going to do it. We're gonna start. It's just hard because it's.
Michael, any idea how long it's been?
Did it last night, I think it was, so for Brian, maybe it's 2 for her. But I think she's gonna try and speed through some of this stuff, and we're gonna be skipping some of this stuff, just because.
She's not terribly long,
Yeah,
but
you're gonna call your investigator, right?
yeah, Lauren's
No,
gonna.
if you wanna put the report in, that's fine, but however you wanna do it.
Okay, that's helpful, thank you. That's a clean copy of it. Actually, that's not a clean copy of it.
I have a copy. Well, it might be. It's a ring. What do you think?
Let's have them lay foundation. What he was asked to do. Public. And what about it?
Kind of. He's trying to explain it to me.
We have to, so think about it.
Okay. judges and
Yeah.
tables.
Thanks, Dad.
All right, fourth district court, state of Utah, Title Section, Youngstown County, after Rapid Peter presiding.
Please be seated. Good morning, and just take me a moment to set up a couple things here. Appreciate your patience. All right, court is now in session. Video recording may begin. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Chad Grunander, Lauren Hunt, Ryan McBride, and Chris Ballard for the state here in the court today, Your Honor. County Attorney Jeff Gray is joining via WebEx, although I don't believe he will be making an appearance at today's hearing.
All right, thank you and good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who is seated beside me.
Good morning to defense counsel, and Mr. Robinson, good morning to you as well. All right, before addressing the business that's before the court today, I want to address some preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during these proceedings will not be permitted to re-enter until the recess. So I just want to give you that heads up. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, I wish to address the camera operator and still photographer, if you would both come forward. All right, so I don't mean to cause you any discomfort, but I just want to ensure the expectations of how we're proceeding today. Could you state your names and your respective roles, please?
Trent Nelson as the still pool photographer for the Salt Lake Tribune.
Thank you, Mr. Nelson.
Adam Fondren, video pool for ABC4.
Thank you. All right, have you both reviewed the court's standing decorum order dated February 24th, 2026?
Yes.
Yes, Your Honor.
And do you understand the requirements set forth in that order as it applies to your activities today?
Yes, Your Honor.
All right. Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No, Your Honor.
All right. Do you anticipate any difficulty with complying with the order?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Fondren, I appreciate your cooperation. Thank you.
Thank you.
Turning next to discovery, counsel for the state, could you give an update?
Your Honor, on April 3rd, I filed a notice of the state of discovery with the court. I don't know if you've seen that, but I attached to that filing a 225-page document that lists the discovery that has been provided, had been provided as of April 1st of this year. There's over 20,000 files. That document has about 100 files per page listed. Discovery continues to come in. I believe it was March 26th, the defense counsel sent a discovery letter requesting special discovery or specific discovery of materials, case files, underlying data, and so forth of lab materials from scientific reports. We're going to address some of that in the motion to continue the preliminary hearing today. Those materials have been requested from the FBI and ATF labs. Both laboratories are responding to that. They're reviewing it, and they're providing information. As of Saturday and Sunday of this week, ATF, or some weeks ago, ATF provided to SBI their entire lab files, their entire case file. On Saturday and Sunday of this week, SBI was able to process much of that material, and we were provided at our office about 1,700 files from the scientific reports from the ATF. Just last night, I was updated that we received some more of those files, and that discovery continues. We're processing that material, bait stamping, cross-checking for duplication, and then providing those materials as efficiently as we can.
Thank you, Mr. McBride. Appreciate that update. All right, the court will now, and to the other parties, did you want to weigh in or comment on that?
Thank you, Your Honor. Richard Novak for Mr. Robinson. I think the status of the specific items of discovery that Mr. McBride was just mentioning is sort of the core of the present dispute about whether the preliminary hearing can go forward in mid-May. So I guess the best thing to do would be to reserve comments about that until the court wants to take up that motion.
Thank you, Mr. Novak. I appreciate your input on that. Well, turning to that, I do want to outline the procedure for today's hearing, and it's to do so in orderly and efficient presentation of the issues before the court. First, we'll be addressing the motion to continue the preliminary hearing, which is set for next month. And what I want to do is I'm trying to manage time as at the same time allowing all parties the ability to present what is necessary in order for this court to make a well-informed decision. And so here's where I'm landing. As it relates to the continuation of the preliminary hearing, I will allow both sides 30 minutes to present what you wish to present to this court. This would include any allocation for rebuttal for defense. Upon conclusion of argument on that motion, the court will proceed to the pending motions concerning media access within the courtroom. Each side will be afforded up to 2 hours to present argument, examine witnesses, cross-examination, and redirect, and respond to inquiries from the court, as well as reserve time for rebuttal. So I just want to create that expectation. Knowing the expertise and experience of the parties, that's probably more time than you need, but I want to create an expectation so we know how to proceed. I encourage the parties to be succinct in presenting the evidence, and the purposes of these time allocations is for case management and not to alter or diminish any of the parties' substantial rights. Following the defense's presentation, the court will recess for approximately 30 minutes, during which time the courtroom will be closed. Proceedings will then resume with the state's presentation. If necessary, members of the media will be thereafter afforded up to 15 minutes for any responses. The court will then take a brief recess of approximately 10 minutes. Upon reconvening, the parties may proceed with closing arguments using any of the remaining allotted time. The court will monitor the time, and argument will conclude upon the expiration of that time. The court anticipates issuing its ruling at a later time via WebEx, as you may come to expect, to permit full and careful consideration of the record and the arguments presented today. The scheduling of that proceeding will be addressed at the conclusion of today's hearing. The court recognizes the significance of the matters before it and the preparation undertaken by all counsel. All participants are expected to adhere to the applicable standards of professionalism, civility, and ethics. The court finds most helpful those submissions and arguments grounded in the evidentiary record and supported by controlling authority and applicable law. Counsel are expected to ensure that their witnesses conduct themselves in a manner consistent with these standards. The court will now turn to the defense. Mr. Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson.
Your Honor, the three docketed pleadings that are germane to the defense's first motion to continue the preliminary hearing are our motion, which is docket number 466, the state's response, which is docket number 476, and our reply, which is docket number 493. I can keep track of my own time, but my expectation is that I won't need all 30 minutes, but whatever I don't use, we'll see if any rebuttal is necessary.
Thank you.
So I think, if I may, the last time we were here and there was sort of a preliminary discussion about the May setting for the preliminary hearing, I think I said to the court, I don't need to reiterate what the court said to us when it set the date. But I do think, in light of the status of specific items of discovery, which I will get to, and the state's position on whether the preliminary hearing can go forward, I do want it to be clear, at least for the record, because I obviously understand that Your Honor knows what the court said, that the expression of the court back in December was that no party would be prejudiced by this setting. And I think that's important because when we look at the status of discovery with respect to the specific scientific evidence we're talking about, and we look at Article 1, Section 12 of the Utah Constitution, and we look at Rule 16, and we look at Evidence Code Section 1102, it is clear that Mr. Robinson is prejudiced by the preliminary hearing going forward as scheduled at this point. And it can't even be remedied in the next 4 weeks. I very much appreciate the update that Mr. McBride provided. He actually provided that to us before the hearing. But the bottom line is that we don't have from the prosecution team, and I'm going to explain what I think the prosecution team means in this context, data which is in their possession, which is clearly discoverable under Rule 16, which is what the Constitution of Utah refers to when it talks about appropriate discovery. And that brings up the reliability question under Evidence Code Section 1102. So there is no doubt that the ATF and the FBI have data files that represent what I'll call the digitization of DNA evidence. The DNA evidence, literally the collected evidence, is physical evidence, which is specifically addressed in Criminal Procedure Rule 16A1C. And then when it's digitized, and it may be that experts will tell me that's not the right word, but when it is converted into data that can be analyzed, data sets that can be utilized in DNA analysis, that's electronic evidence under Rule 16A1C. And we don't have that, and Mr. McBride acknowledges that we don't have that, and when I say we, I mean the defense, from either the ATF or the FBI. Now, Mr. McBride, I think, said to the court, he did say to me, that the ATF has just recently given SBI some files. SBI has turned over some of them to the Utah County Attorney's Office, but not all of them. The defense has not yet received them. So neither Mr. McBride nor I actually know if these data files, the raw data upon which all DNA analysis has been done, or have been produced from the ATF to SBI, and we don't know if it's gone from SBI yet to the Utah County Attorney's Office. The FBI has not turned over anything, according to Mr. McBride, that might include the data files because there has been no production by the FBI in recent months in what I'll call the DNA area. We did make what Mr. McBride called a supplemental discovery request some weeks ago that set forth with great specificity the forensic-related documents and materials that we want, including those data files. That's actually attached as an exhibit to our motion. But that was not the first time that we asked for these data files. And I am not casting aspersions at Mr. McBride and his team, because those data files are in the possession of their federal law enforcement partners. We're not asking somebody to go looking for a needle in a haystack. Hey, there might be some piece of evidence somewhere. Can you go looking? We know that these data files exist because we have summary FBI and ATF reports summarizing the data analysis that go all the way back to September. So I actually think that one of the questions, if I may, one of the questions, because counsel don't ask each other questions in the courtroom. We understand that all questions are asked by the court. Why hasn't the FBI turned over these data yet? And why hasn't the ATF clearly communicated until very recently whether it has and why it has not? The state's opposition to our motion does not explain why the data files have not been turned over. So now what I want to talk about is the significance of the data files. We have a right at a preliminary hearing to both examine and cross-examine witnesses. And our right to present witnesses includes presenting expert witnesses. If the state doesn't want to call the forensic examiners at the FBI and the ATF to testify about their analyses and the conclusions, that's their choice, but we have a right to present evidence that gets at these DNA issues, and we have a right to do that through expert witnesses. We cannot do that when the law enforcement partners, ATF and FBI, have not provided us with appropriate discovery. That's the phrase in the Constitution, appropriate discovery. So that appropriate discovery is the gateway to reliable hearsay at a prelim. It is meaningless for us to have the right under the code to present and cross-examine, present our own witnesses and cross-examine witnesses when we don't have the electronic evidence, that is these data files, that comes from physical evidence, the DNA swabs. It's a meaningless right, and it frankly makes a mockery of the reliability concept. We have identified for the court in public pleadings 2 DNA experts who we have retained who are waiting for these data and for other materials so that they can advise us on whether the opinions expressed in these reports, these are ATF and FBI forensic reports on the results of their DNA analysis, whether these reports are reliable. And if they are, if they're not, cannot be determined without that underlying data, those underlying data. So we have the experts, they're waiting for the data. We don't have the data. It's not Mr. McBride's fault. It's not SBI's fault. It's the law enforcement partners who have had these data files since September. Like, it's been over 6 months. And many of the DNA reports that they produce are also dated September, and I could go through each one of them if necessary, but maybe I'll do that in rebuttal because I don't want to run out of time. So We can't present any expert testimony on DNA without having the underlying data. Second step, if the state doesn't want to call the forensics examiners from the ATF and/or the FBI as witnesses, we also have the right to call them as witnesses. We have a little bit of a jurisdictional problem because we're in state court and we're not in federal court, and so we have these TUI regulations, which I'm sure the court is familiar with and are addressed in our reply brief. And I have personally been in contact with counsel for the ATF and counsel for the FBI who have not said, yes, we will make these witnesses available. They have said, why don't you get us some subpoenas, which are, by the way, not enforceable, but they're subpoenas, and could you give us a more definite statement of exactly what you want them to testify about? But I can't examine those witnesses without the data and without the data files being evaluated by our DNA experts. The state's suggestion that we just put these reports in through Rule 1102 before really calls into question the concept of reliability, because there is no way for this court to evaluate the reliability of those conclusions. There is no adversarial testing if I don't have those data, if I haven't been able to give those data to our DNA experts, if they haven't been able to tell us what they think of the data vis-a-vis the conclusions in the reports. So we have a problem with adversarial testing. It's a critical stage of the proceeding. We are basically handcuffed under the state's proposal, which is the court receives into evidence reports which we cannot in any way address the reliability of. And so this actually goes all the way up to the Utah Constitution, which says that reliable hearsay is admissible if we have appropriate discovery. Appropriate discovery, again, is the constitutional phrase. But it also implicates, because it's a critical stage, Mr. Robinson's Sixth Amendment right. And as I addressed in our reply brief, the heightened reliability concerns that the Constitution reminds us of in any capital proceeding. And heightened reliability isn't just reserved for penalty phase. And I provided the court with a number of cases which talk about heightened reliability being something that is a gloss over the entire proceeding. So the court, in my opinion, needs to, and in light of the law here, needs to say to the state, I can't do the prelim until the defense has the data files in a reasonable period of time. When are we going to get the data files from the ATF and the FBI? And if Mr. McBride, given all of his due diligence, can only say to the court, I don't know, because the FBI hasn't told us when, and the FBI hasn't told us why, then we're just going to have to wait. We're not interested in postponing this for the sake of postponing this. We're interested in having a meaningful testing of expert reports, which the state wants the court to just receive into evidence under 1102b4. And that's not reliability. That's not reliability under the constitutional test, which requires appropriate discovery first. It's not reliability under the Fifth, Sixth, and Eighth Amendments. And I'm not in the business of telling the prosecution in any jurisdiction how they should do their job, but the state chose to proceed by way of preliminary hearing instead of proceeding through a grand jury, and this is where we are. We have a right under the Constitution to have appropriate discovery before this court receives into evidence what the statute says is reliable hearsay. And if the court says, oh, you don't need the data files, then we believe that 1102B4 is unconstitutional, as applied in this case. If we have the data files and a meaningful time to evaluate them, then the state has fulfilled its obligations under the Constitution, and the reports can be received, at least statutorily, as reliable hearsay, subject to our right to present evidence through direct witnesses and through cross-examination. So I think, other than what I've said so far, I would be repeating myself, and if I've not used my 30 minutes, then I'll save the remainder for rebuttal.
Thank you, Mr. Novak. Turning to the state.
Is that okay if I disconnect it?
Yeah, sure.
Trina, do you mind allowing me to present? Your Honor, the court should deny defendant's motion to continue the preliminary hearing simply because the reason the defense has requested to continue the preliminary hearing really has nothing to do with the preliminary hearing. It's unnecessary, the continuance is. It's necessary to expert discovery, it's necessary to expert notice, it's necessary to a 702 hearing, it's necessary to a trial determination of the weight to give to expert testimonies, but it is not necessary to a preliminary hearing. Now, before I jump into my argument, Your Honor, is my screen sharing? Yes, can you see it there, Your Honor, on your?
Well, let's see.
We're not seeing anything at council table.
I'm not sure if it's being presented yet.
Make sure I've got my settings right here too. Well, I'll assume that will come up as I'm talking, Your Honor, but before launching into my argument, I want you to understand my structure here, okay? My first point that I'm going to make is the defense has not shown that a continuance is necessary to the purpose of a preliminary hearing. Maybe necessary for other reasons, this material, but not necessary. Maybe this material and discovery of this material is necessary for other purposes, but not for the limited purpose of a preliminary hearing. And the second point is the rules don't require expert notice before the preliminary hearing. Look at Article 1, Section 12, Rule 16, Rule 7B, Rule 1102. They don't require expert notice before the preliminary hearing. Now, I want to start with that first point, which is the real standard, the salient principle from whether it's Longcrier or Lopez is you don't grant a continuance unnecessarily, right? Axiomatic, right? That's the salient principle from those cases. That's what common sense says. You don't unnecessarily continue a hearing, right? Why? Well, because it causes delay in the proceedings. In this circumstance, this is not a nominal delay. We're talking at least 6 months for the defense to get this material, review it, and consult their experts, and for their experts to be ready to present expert testimony. But more likely, even more than that, because there's litigation surrounding some of this expert investigation. One of the tests right now has not been performed because there's an objection to it, and we're waiting to litigate that issue depending on what some of the expert discovery shows. In addition, we're probably going to object to some of the expert discovery requests the defense has made and that they made on March 25th. So this is at least a 6-month delay, probably much longer than that because some of these expert issues have to be litigated. And when you consider the purpose of the preliminary hearing, right, it's an initial stage of this process, right? It's designed to protect a defendant from having to sit in custody and wait for all the trial preparations without there being any showing of any evidence, right? The Rule 16, the preliminary hearing is designed to ferret out groundless prosecutions. Probable cause is a very low standard. Reliable hearsay is admissible. The court doesn't weigh the evidence at this stage. And that's because this is a very early stage of the proceeding. And the rules contemplate discovery and investigation ongoing throughout and even past the preliminary hearing and even all the way up until trial. So the question is a continuance necessary for the purpose of a preliminary hearing? And to understand that, you have to understand two things. One, what is the purpose of the preliminary hearing? And two, what is the evidence that's likely to be presented at the preliminary hearing? And then you get to three, is a continuance necessary? First, the purpose of a preliminary hearing is clear. There's very few principles in Utah law that are more clear than this. There is one purpose to the preliminary hearing and one purpose only, and that is to determine probable cause. Every time a defendant or a trial court tries to expand the preliminary hearing beyond that, whether it's on constitutional due process grounds or discovery grounds or something else, the courts uniformly and repeatedly reject those arguments. There's only one purpose. It's clear in the Constitution. It is to determine probable cause. It's not a discovery hearing. It's not a due process notice hearing where the defense learns what the state's theories are or what evidence the state is going to present at the trial. It is not a suppression hearing under the Fourth Amendment. It's not an admissibility hearing under the rules of evidence. And it's certainly not a 702 hearing. It is only one thing, a probable cause hearing, and that's it. That's important because that relates to what a continuance being necessary means, right? Can the defense show they need to continue this hearing because it's necessary to a determination of probable cause? If they can't, it's unnecessary and it's going to infringe on the victim's right to a speedy trial, as well as the state's ability to present the case. Justice delayed is justice denied, as the saying goes, and that's because it affects a victim's right to a speedy trial. It affects the public's perception of legitimacy of the prosecution and the judicial system, and it has real effects on the evidence that may be presented at trial. Witnesses become unavailable, memories fade, evidence grows stale. And so the court should not be granting a motion to continue and delaying the proceedings unless it's necessary, especially for such a lengthy period. The next stage in understanding whether or not a continuance is necessary is, one, understanding the purpose, the limited purpose. Two is, what's the evidence going to be at the preliminary hearing, right? Because if you understand what the evidence is going to be, then you can determine, well, is what the defense wants, is that going to affect probable cause determination? The only way to know that is to know kind of what the evidence is going to present. That's why Lopez says you listen to the evidence first, and then you should consider, in that case, whether or not the defense should be able to subpoena the victim. And I think the same analysis applies here. Listen to the evidence first, then you ask the defense, well, what are you going to present, and will it be necessary, will it be relevant to a probable cause determination or not? Put another way, will the defense be able to show that whatever evidence they want to present is likely to defeat probable cause? If they can't make that showing, it would be an unnecessary continuance. So let me give you a proffer of what the evidence will be at the preliminary hearing. There's really four categories of evidence. The first is surveillance from UVU. Now, UVU has a great surveillance system, and they capture the defendant coming on to campus at about 7 a.m., or I think about 8 a.m., okay? It's clearly him. He's driving his gray Dodge Charger. I should say he's from St. George, so this isn't just a casual passing by Utah Valley University. This is a 3.5-hour drive from his home, 250 plus miles from his home. They capture his car pulling into the Utah Valley University parking structure. He gets out of the car. He's wearing his favorite Hurley hat, a maroon T-shirt, shorts, and Converse shoes, the same clothing he's wearing when he turns himself in the next day. Clearly him. There's good facial images and everything. He walks around campus and he scouts campus out. He then leaves the campus. UVU surveillance then captures him return later. He returns on foot right before the Charlie Kirk event. He's wearing a disguise of sorts. He's wearing a baseball cap, different baseball cap, pulled low. He's got sunglasses on, a different shirt, different pants, but the same Converse shoes. That's all seen in the surveillance. He's limping because there's a rifle down his pants. The surveillance captures this individual. Again, I don't want to overstate the evidence because The pictures of his face at this time are not as definitive as they were earlier because of the sunglasses and the hat. But it captures his face, captures his appearance, his height, his build, all consistent with how he looks earlier in the day and how he looks today in court. But he makes his way to the rooftop, makes his way to the sniper's perch on the rooftop, takes the shot, and then runs to the northeast, drops off the building and runs to the northeast of campus into a wooded area. That's all captured on video. Okay, that's the first category of evidence, is the video surveillance that shows the defendant on campus taking the shot. The second point is circumstantial evidence tying him to the rifle. Right? In that wooded area, police find the rifle. In the rifle is wrapped in a towel. In the rifle, they found 4 rounds. And these are .30-06 Remington rounds that have, 1 has been fired, 3 have not, consistent with the shot at Charlie Kirk. And all of these rounds are unique in that they have inscriptions on the brass. There's etchings on the brass with little political messages. Well, after the defendant turns himself in, there's a search warrant that's executed on his house. In that house, police find a Dremel tool, and they also find the same make and model of ammunition, Remington .30-06. And not only that, but one of these rounds has etching on it, consistent with the etchings on the rounds found in the rifle, right? The etching found at his house says, test shot, right? So that's the second category of evidence, is the circumstantial evidence tying him to the murder weapon. The third category of evidence is confessions. The state will present evidence that he left a handwritten note at his apartment for his lover to find. In that note, he says, I had the opportunity to take out Charlie Kirk, and I took it. Right? This note was written before he left St. George and came to Orem, and was left in his apartment. His roommate finds it, roommate/lover finds it, and this initiates a text message conversation back and forth between the lover and the defendant, where the defendant says, yeah, I shot Charlie Kirk, and I'm summarizing, shot Charlie Kirk, I left the rifle behind, I had to leave the rifle behind, but I'm going to pick it up and then I'm coming home. Then he also confesses to a group of friends on a messaging application. Before he turns himself in, he says, hey guys, it was me, I did it, thanks for all the good times, goodbye. And the final confession is an acquaintance is a former law enforcement officer, and he helps arrange the defendant turning himself in to the sheriff's office. And when he's talking to that former law enforcement officer, he says, I got rid of the clothing I wore. Right? So there are 3 categories of evidence that have nothing to do, that show probable cause, have nothing to do with the DNA evidence, which is what defendant's issue is here. The 4th category of evidence is that DNA evidence. And you have to understand what that DNA evidence is. The towel that the rifle was found wrapped in was sent to the FBI lab for testing. There was also a screwdriver found on the sniper's perch that was also sent to the FBI lab for testing. The rifle itself was sent to a different lab, the ATF lab, for DNA testing. And both labs tested those materials completely independently of each other, different analysts, different labs, different locations. Both of them come back showing the defendant's DNA on those materials. Okay, the screwdriver, the towel, and the gun. I say they found the defendant's DNA on those materials. The experts and the reports that we'll present at the preliminary hearing were much more precise than that, right? Really what they say is there's astronomical odds that this DNA belongs to anyone but the defendant. But you'll see that, and I think you take my meaning here. The point is that there is substantial evidence of probable cause, far exceeding what probable cause requires. And it comes from a variety of sources. And so the defendant cannot show that the material he wants to present at the preliminary hearing would defeat probable cause. And in his reply, he says, well, that's circular, because how could we make that showing if we don't have the underlying data to be able to attack the DNA evidence? Well, first of all, that attack wouldn't even affect those first 3 categories of evidence, right? The confession, the circumstantial evidence tying the defendant to the rifle, or the video evidence, right? But even if they were to find some expert that would say both labs independently got this wrong, and even if they're to find that kind of expert, which I think is speculation and probably against the grain, but regardless, you take that assumption, it still wouldn't defeat probable cause, because at this stage, the court doesn't weigh contrary evidence, right? The standards are very clear. At this stage, because it's such an early stage with such a limited purpose, the court views all evidence in the light most favorable to the state, right? That's State v. Virgin. So, in summary, the defense has not shown that the motion to continue is based on the purpose of the hearing, a fair determination of probable cause. They just haven't shown it, and they haven't even tried. And I think one of the reasons they haven't tried is because they know that these are experienced practitioners. They know what the standard is here. It's low. The evidence is viewed in the light most favorable to the state. They're not going to be able to defeat a confession, multiple confessions nonetheless, or DNA evidence, right? And if the continuance was granted, it would affect the victim's right to a speedy trial. And frankly, like the Lopez case, it would obviate the repeated and express admissibility of reliable hearsay at preliminary hearings. And that leads me to the second point, which is a textual analysis. So the defense says, well, Article 1, Section 12, Rule 16 require expert discovery before the preliminary hearing. Let me try to see if my computer will present again.
It's not outputting the video from your laptop.
Let's see. I'm showing it's connected. Oh, there we go, great. Okay. So let's look at the text of the rules, right? Utah Constitution, right? Here it is, Article 1, Section 12. Where the defendant is otherwise entitled to preliminary examination, the function of that examination is limited, right, to one purpose, as I said earlier, to determining probable cause. Nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule, in whole or in part, right? In any preliminary examination to determine probable cause, if appropriate discovery is allowed, as defined by statute or rule. Is it allowed? Well, Rule 16 allows it. That's the end of the inquiry. Well, the defense says, well, no, but it has to be complied with, and that's fair, I guess. So let's look at Rule 16. So here's what Rule 16 says. Look at the mandatory disclosures, and there's a distinction here that I think is important. One is the use of the language here, prosecution team. When we talk about mandatory disclosures under A1, we're talking about what the prosecution team has, right? Prosecution team has been interpreted in case law to mean the prosecutor as well as the law enforcement people who are working on this case. But if you go down to the timing of mandatory disclosures, it's different language that's used here, right? And I've highlighted the portion that applies here. 8, there it says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination. Okay? The different language is the prosecutor versus prosecution team. Had the Supreme Court Rules Committee, and as approved by the Supreme Court, had they wanted this to mean full discovery of everything in everyone's possession before the preliminary hearing, they would have said so, right? The rules of statutory construction say you presume all omissions are intentional, right? They use distinct language here, and they did it for a reason. The reason is because the preliminary hearing is such an early stage of the proceedings, right? We all know investigation at the preliminary hearing stage is continuing. We all know the state, the prosecutors are still getting material from the investigative agencies. We know investigative agencies have processes for getting reports and approving reports and disseminating reports. We know expert witnesses, oftentimes by the preliminary hearing, haven't even started their work, right? The Rule 7B says the preliminary hearing has to take place within 14 days where it's requested, right? This is a very early stage of the proceeding, designed to protect the defendant from having to sit in custody where there's no showing of probable cause. And the rule itself, Rule 16, makes clear that discovery is ongoing. It foresees that discovery is going to be ongoing throughout the trial. So the defense argument that Rule 16 requires full discovery of this material before the preliminary hearing is a contra-textual reading. But even so, you look under A1, and what does A1 actually require as mandatory disclosures? Well, there's a specific provision that talks about scientific tests and experience. It's A1B, reports and results of any physical or mental examination, of any identification procedure, and of any scientific test or experiment. We've provided those reports. Okay? What the defense wants is complete and total expert notice and expert discovery. We've even complied with A1 as it relates to what the prosecution team has with regard to the reports. Okay, so Article 1, Section 12 doesn't require discovery before the preliminary hearing. Rule 16 doesn't require full, complete discovery before the preliminary hearing. Well, is there any other provision of authority we should be looking at here? Well, how about the provision of authority that is directly on point with regard to expert notice? Let's take a look at that. 77-17-13. 1A, if the prosecution or the defense intends to call any expert to testify in a felony case at trial or at any hearing, excluding a preliminary hearing held pursuant to Rule 7, the party intending to call the expert shall give expert notice, right? It's hard for the defense to make an argument that expert notice is required before the preliminary hearing when that's not even an against the grain reading. That's a completely contrary reading to the statute directly on point. The court would have to find that this section does not apply, and it's just impossible to do that. Well, the defense may say, well, we're not requiring expert notice. What we're asking for is just discovery here. Well, no, what they're asking for is, in fact, expert notice. Rule 77-17-13 talks about what expert notice is. If you look at B, right, it's a CV of the expert, the report, written explanation, and then 2 says an expert's anticipated, if it's based on specialized data, the witness shall provide the opposing party the information of that specialized data upon request. Well, the expert notice request, let's see if I can find my list here. It's this one. Let me give you a list of what the defense requested in their March 25th request. And I should mention, the defense is right. This was not the first time they asked for this material, but when they asked for this material, this specialized data underlining the report, I responded by saying, look, I don't know exactly what you want. You know, you talked about like certain software files and stuff like that. Will you please put it in writing so I don't lose what you want in the translation? And so they did. So on March 25th, they gave me this supplemental discovery request, and that's what I've relayed to the agencies. But what they want is lab case files that the government intends to use in its case in chief. I should note that the FBI has provided a lot of this material already. I provided a case file that's 380 pages long, I think clear back in October, as well as about 77 other files that list their policies and procedures. And those are listed in that 225-page document that I attached in my April 3rd filing. But they list CVs of analysts, accreditation documentation of the labs, accreditation documentation of the programs used to interpret data, standard operating procedures and protocols, STR databases and frequency tables, chain of custody documentation, data files underlying the analysis, software names and software versions used, developmental validation of instruments and processes, internal validation of instruments and processes, proficiency tests of analysts, audit records. All of that material may go to expert qualification, the qualification of the labs, the methodologies, may go to 702 issues, but it doesn't go to probable cause, okay? Especially when you've got to view this evidence in the light most favorable to the state. And the final reason why we know that expert discovery, expert notice is not, I didn't finish my point here, which is this material they're requesting is expert notice. Like, that's what they're requesting here is expert notice under 77-17-13, which expressly does not have to be given before the preliminary hearing. And I should say, regardless of the fact that we're not required to give expert notice before the preliminary hearing, we're doing our very darndest to do so. And we shouldn't be penalized for being on the ball and getting ahead of things by trying to get the expert reports and investigation done as soon as we can. To the contrary, that's the kind of behavior and due diligence that should be encouraged and incentivized. And if you say, no, you can't have a preliminary hearing until all of that is done, it does create chaos in the system. Because it says, if I want to have a preliminary hearing early, I'm going to stop my investigation once I hit probable cause, because then I don't have these discovery problems before the preliminary hearing. And that is not the type of conduct we want to incentivize, and the rule doesn't incentivize that conduct. And this comes to my final point. The defense knows it, okay? I know that Mr. Novak has made his argument here, but the defense knows that this kind of material is not required before the preliminary hearing. And how do we know the defense knows it? Because the defense has said so. In one of their earliest pleadings in this case, docket number 16, I think it's 16, the defense counsel filed their request for discovery. This is the formal request for discovery that's filed, I think, docket 16. And in that docket, they recognize that discovery is an ongoing process. You get down to page 11, and the defense cites Rule 16 saying, the prosecutor's duty to disclose material is ongoing. In every case, all material that is presently and reasonably available to the prosecutor must be disclosed before the preliminary examination, right? But here's the key phrase that I think shuts the door on this argument the defense has made, is highlighted in red there. And I quote, defendant acknowledges he does not have a right to discovery prior to preliminary hearing pursuant to Article 1, Section 12 of the Utah State Constitution. That's it. The defense concedes this point. Now, the point I'm making is what the defense makes right here in the next sentence. However, defendant relies upon this initial discovery request through trial, post-preliminary hearing, to enforce their rights encompassed in the Utah Constitution to a fair, speedy trial. That's the point I'm making, is the state should be pursuing expert investigation, their due diligence, getting the investigation done as early as possible, and providing that discovery as it comes in on a rolling basis, right? And that's what we want to have happen. We shouldn't punish the state and the victims and everyone else by delaying the proceedings when the state does exactly what has been done here, which is getting on top of those things early, right? I think that's all I have, Your Honor. Do you have any questions for me?
I will. I'm going to turn to defense for their rebuttal and then have questions for both parties. Thank you, Mr. McBride.
Thank you, Your Honor.
Forgot one piece of equipment. Thank you, Your Honor. I do want to respond directly to a number of the arguments that Mr. McBride made, but I also want to refer the court back to the accusatory pleading which initiated this case, which is the information. The information specifically relies upon two types of DNA evidence. First, the information, and it's actually the probable cause statement in the information, docket number 1. At the bottom of page 3, the probable cause statement alleges that DNA consistent with Robinson was found on the rifle's trigger. Second, the probable cause statement in support of the information says, in the middle of page 6, the rifle, ammunition rounds, and towel were sent for forensic processing. DNA consistent with Robinson's was found on the trigger, other parts of the rifle, the fired cartridge casing, 2 of the 3 unfired cartridges, and the towel. We have not received the discovery, and I'm not talking about expert notice, I will address that. We have not received the physical evidence and the electronic evidence that supports those assertions made by Mr. Gray when he swore to the probable cause statement attached to the information. We are not talking about the broad scope of expert notice, of expert discovery that Mr. McBride is talking about. We're talking about physical and electronic evidence, which first, the information was based upon, as I just said. And then second of all, as Mr. McBride acknowledges, the state intends to present the limited DNA evidence that it has without even having the data files been made available to us. And I want to drill down on this very specifically because I think it's appropriate, but the state sent us, but did not file with the court, a memo outlining the witnesses they intend to call at the preliminary hearing and the exhibits that they intend to offer at the preliminary hearing. And I'm going to respect that it's their present plans, and it's not something that necessarily should be filed under seal, filed publicly. But as Mr. McBride acknowledges, that includes 3 DNA reports. We have those reports. We just don't have the data that the authors of the reports relied upon for those conclusions. And I'm not talking about their CVs, I'm not talking about their published writings, I'm not talking about their prior testimony, I'm not even talking about all of the things that Mr. McBride acknowledges we've asked for and that there may be a fight about later in terms of discoverability under Daubert, under 702. We're talking about a core data file. It's literally a data file, one from the ATF and one from the FBI, that they generated back in September that hasn't been provided to us. So we can't provide that to our experts to help us assess whether or not there are reliability problems with the reports that the state wants to offer through 1102B4. So we're not talking about the slippery slope and months of litigation of Daubert-type expert notice. Mr. McBride is right that at a certain time and place, there will be discovery litigation related to experts and then admissibility litigation related to experts. That's not what we're talking about here. We're talking about very concrete data files that our experts are waiting for. And when I say data files, I literally mean the digitization of physical evidence obtained from our client and from these objects. We didn't choose for the state to present DNA evidence at the prelim. That's their choice. And that's why we are having this dispute right now. The question that I think this court needs to also address is when Mr. McBride talks about what discovery is, quote, reasonably available to the prosecution. How can this court conclude that not having these data files is reasonable, given that the ATF and the FBI generated these data files from the swabs months ago? They've concluded their work, as far as we know. They've generated reports. The state believes that the reports are sufficiently final that they would offer them into evidence in a preliminary hearing. So I think this court should make the finding that those reports are reasonably available and that they should be produced to us. Mr. McBride, probably because he can't, still hasn't told the court why we don't have the data files. So where Mr. McBride, with all due respect to his advocacy, because he's a fantastic advocate, goes, is he goes into the slippery slope of expert discovery and expert notice and Daubert, and that's really not what we're talking about here. We're also not talking about the bullet fragment further testing issue, which has previously been described as the January 9th motion, which the court unsealed. That is not a DNA issue. That is about what happens to a bullet fragment when a federal law enforcement lab wants to do what they call destructive testing. It's not to get DNA off of it. It's to look at whether that bullet fragment can be related to the other evidence in the case, because the ATF's first conclusion, as the court knows, is that they couldn't say either way where that bullet fragment came from in terms of firearms. So that is not what we're talking about here. There is a ballistics report that the state wants to offer into evidence at the prelim, but we're talking about DNA reports. And I do want to say, however, that we are not suggesting that the preliminary hearing be postponed until this dispute about the destructive testing of this bullet fragment is resolved. But it was a federal law enforcement lab that said, we're not going to permit a defense expert to observe the destructive testing, and we're not going to videotape the destructive testing. We're going to do this behind closed doors. But that's not what we're talking about here today. That's a different issue for a different time. And I don't think it has anything to do with when the preliminary hearing occurs.
Mr. Novak, just to be consistent, do you have some final thoughts as your time is coming to a close?
Yes, thank you. My final thought is that this court should direct the state attorneys to find out when the data files will be produced. And once we know that date, and they actually are produced, then we've already told the court that there's a concrete amount of time that our experts need in order to analyze them. Otherwise, I've already argued about the constitutional and legal principles that are at stake here, and I think that the court has those in mind. I also want to say, finally, the Lopez case has nothing to do with this. I understand it's a Supreme Court decision, but the Lopez case is about a defendant who tried to serve a subpoena on the victim of a sex offense to have the victim testify at the defendant's prelim. That is not what this is about. We're not fighting about a subpoena. We're not talking about victim testimony. It's really not applicable. Thank you, Your Honor.
All right. Well, I'll have questions for both of you. I'll start with Mr. Novak. Again, thank you both for your presentations today in such a succinct manner. The court appreciates that. So one of the questions that's before the court, and Mr. Novak, it goes to the heart of the matter for this court as the court is weighing whether the continuance should be granted or not. Has defense reviewed all the discovery that has been presented up until this point in preparation for a preliminary hearing set for next month?
We have reviewed the discovery that is tied to the exhibits that the state intends to offer at the prelim where there is discovery available. If the court is saying, have you reviewed the thousands, have the lawyers reviewed the thousands and thousands and thousands of pages of discovery that are well documented in the index that Mr. McBride provided the court privately? The answer is no. Our paralegals are doing their best to organize it, but have counsel reviewed that discovery and have we had a reasonable time to do so? No, because it's gigantic and it's voluminous. We know that some of it has nothing, some of it has been provided in what I guess the state would call an abundance of caution. 30 days worth of surveillance video from UVU. We don't believe that we even need to review 29 of the 30 days. So we're not going to waste time and resources reviewing hundreds of surveillance camera hours without some suggestion that we need to, and we don't believe that we do. Have we reviewed, every FBI report interviewing people who claim to have known Mr. Robinson or known his roommate? Yeah, we've reviewed all of that. Have we reviewed the forensic materials that we have received? Yes. Have we reviewed all the law enforcement reports about the events at UVU? I mean, I can only speak for myself. No. Because it's so voluminous that we haven't had that time.
Well, in really the heart of my question is, have you reviewed all the discovery that has been passed that enables you to be prepared for a prelim next month? That's, that you're saying is applicable to what you understand the state will be presenting, or what you need to review. Just because the state says they're going this direction, you have to do an independent determination of the discovery on what you need to review to be prepared. And so my question is, have you done that, and are you there?
No. So, for example, we received a couple months ago an external hard drive that had thousands and thousands of gigabytes, I don't even know how many, of material taken from digital devices, taken from search warrant returns from what I'll refer to as social media communication platforms, Discord and all of the others. No, I haven't had time to do that. Absolutely not. My clients, so there's a huge download of my client's cell phone. There are downloads of many, many, many digital devices. No. Absolutely not.
But my question is, in order for you to be prepared, you've made the argument there's a lot, and there's no dispute that there's a lot of discovery, to say the least. But you've also said that you don't need to review it all, you just want to review what's relevant for the preliminary hearing. And so my question goes to, have you reviewed all the relevant discovery that's been passed to be prepared for a preliminary hearing? That you have in your possession now?
I can only speak for myself. I'm not going to speak for other counsel, but the answer is no. The answer is no, but I am not able to, maybe this isn't the court's question, but I'm not even able to approach this fourth category of evidence that the state wants to offer at the prelim, which is the DNA evidence, because we don't have the underlying data files to be able to assess what to do about those reports. So if the court said to me, Mr. Novak, have you reviewed all the drone images that they want to use? Have you reviewed all of the video that they want to present? Have you reviewed all of the UVU surveillance? And by the way, this is a letter we received on April 4th. Have you reviewed all the Discord chats that they want to present? No. And I believe I've been diligent.
Would you like time to confer with your counsel? Because I need to know that information. I need to know that if we move forward with the preliminary hearing, either next month or a different date, that there's effective assistance of counsel moving forward. And that's one of the factors is, have you reviewed the necessary discovery? Typically in criminal cases, defense attorneys say, hey, I haven't been able to for whatever reason, and the court recognizes that, right? Like, I get it, but I need to check that box and say, okay, defense is saying, we're ready to go forward with the discovery that has been provided. That's the part I want to be sure is been accomplished. And so as you're presenting for the defense, I would ask you to confer with your counsel, because I understand that you've probably parsed out different areas for each counsel, given what's there, but I need that answer as it relates to the defense team.
I now understand the import of the court's question, and I appreciate that the court has clarified that. So we can present that information verbally, we can present it shortly thereafter in writing, however the court wants to present it, but I understand that. So I'll just give the court by way of an example. I have not personally, and I don't think any of the other counsel have, but we should probably take a short break and we can discuss that, reviewed significant portions of the electronic discovery. And when I say electronic discovery, I mean images of device downloads, as well as, sort of cloud-based information produced to the state pursuant to subpoenas for chats, postings, gaming communications. I mean, the primary platform is Discord with a capital D. It's a thing.
Sure.
Right? So I think I'm just repeating myself, and maybe that's because obviously I would want to speak with my
Sure.
co-counsel
No,
and
I-
not speak for them.
And I respect that. I understand that you're being cautious and you don't want to present something that someone may or may not have reviewed. So I respect that, and you'll be given time to do that. But that's an important factor for the court to determine.
Totally understand. I mean, we've been trying to focus on the very specific items of discovery that we don't have, which relate directly to evidence that the state wants to present at the prelim. And the court is asking, I think, very helpfully, a broader question. And the court is not challenging, the court is not really confronting us on the question of diligence, so I'm not even going to go there. But obviously, there's been a lot of pretrial litigation on a lot of different issues. And as the court knows from our filing yesterday, there's more coming.
Right. No, and I appreciate that. And the court's intent is, I just want to make sure that when we move forward, we can move forward properly and uphold the constitutional rights of Mr. Robinson and all parties, to ensure that what we do is proper and appropriate, because quite honestly, I don't want to do it again. And so, and I recognize, and I can do so, that both sides have been very diligent and have worked extremely hard. Obviously, I'm not in your offices, I don't know your communications, but it is evident to me that both sides have. And so the purpose of that question is, that's just a checkbox I need to know to move to that stage, and only your team has that answer. And again, and I recognize the amount of discovery that's is out there, and so it is no way to impugn defense at all, saying, well, you're not doing your job, you're not working hard, not at all. I just want to know that answer, and so that's
I
the sole
appreciate that.
purpose.
And I didn't feel that the court was making those assertions. And I want to say, we hear that the court doesn't want to do it again. Mr. Robinson and his family don't want to do it again. Counsel don't want to do it again. We know that the state doesn't want to do it again. And we also don't want Mrs. Kirk and her family to have to go through it again, because that's actually, in my opinion, the greatest harm to surviving victims in a case like this is the long run when cases don't proceed as the Constitution requires.
And so going to that point that you just asked, so how do you propose the court balance your request for a potentially large, a long delay against the constitutional rights of the victim representative, Ms. Kirk, in her right to a speedy disposition of the case? For example, I noted in your motion, you stated that your DNA expert needs, I believe it was 6 months.
That was her estimate.
And so how do we balance that? And I appreciate your statement, but going to your statement as it relates to Ms. Kirk's right to a speedy disposition of a party outside, right? Not counsel from either side, but it seems like we're going to be held to the timeline of somebody outside who's an expert who's saying 6 months. And that concerns the court about that is a potential hangup of, well, we can't move forward until we comport with their timeline, and that's concerning. So how do we reconcile that?
Well, first of all, if the expert needs 6 months, the data files were available in September, which was 6 months ago. And so I actually think, while I will answer the court's question, another important question is, why haven't the FBI and the ATF provided data files that they utilized 6 months ago? And Your Honor can't answer that question, and I can't answer that question, and obviously Mr. McBride can't answer that question. And so I actually think, and I don't purport to speak for the victim representative, but that's a question that the victim representative should be asking, at least through her counsel, is why haven't the federal law enforcement agencies, which took responsibility for this analysis, provided the data? Not the CVs. I mean, I've actually examined at least one of these FBI forensic examiners in another case. I have her CV. That's not my issue. We cited in our reply brief the cases which show that the victim's right to a speedy trial does not, I'm sorry to use this word in the current environment, but that's the word we use, does not trump, lowercase t, the defendant's constitutional rights. We do not want the victim representative and her family to have to wait any longer than we have to wait. But it isn't sufficient for the state to say, we've turned over gigabytes and gigabytes and the defense, doesn't really need to review it before the prelim. That's not, obviously, and the court, I think, tends to agree with what I just said, that doesn't make a lot of sense. So we do respect the concerns of the victim representative and her family, but we can't constitutionally shortcut Mr. Robinson's right to the adequate assistance of counsel. And I think, as we said in our brief, when the state doesn't give us the data that their law enforcement partners have and have had for 6 months, we can't be constitutionally effective. And, and again, I keep talking about Mr. McBride because I appreciate his advocacy, but if the state didn't want to have to deal with Article 1, Section 12, the concept of appropriate discovery, this court's need to apply constitutional standards of reliability, Mr. Gray could have presented this case to a grand jury. And instead, what Mr. Gray did was he filed an information with probable cause that relies on multiple assertions of DNA results. We should have had that discovery under a different rule immediately. If he had reports that are based on these data files, when he filed his information and probable cause, those data files existed. Those data files must have existed on September 15th or whatever the date of the information was. And here we are past April 15th. So I will confer with my colleagues on the court's question. We will obviously answer it because it's an important question. If the court has other questions for me,
I do. And
I'm
so
prepared.
going to the state's argument that there's these 4 prongs that can be pursued in regards to the categories of evidence, and that the standard is clearly articulated in State v. Virgin, and so my question for you is, if the state's presenting evidence that can meet the standard in any of the 4 prongs, is it necessary that all the discovery for all the prongs be turned over in order for the defense to be ready to proceed at the prelim?
I'm not going to speculate about how the state's presentation at a preliminary hearing would go as to prongs 1, 2, and 3, nor could I concede that without seeing the way the witnesses testify and which reports are actually received into evidence that they establish probable cause. It's the state that wants to present DNA evidence through summary reports, not through the witnesses, who wrote the reports, not through their own state lab analysts. So it's not for me to comment on categories 1, 2, and 3. I understand what Mr. McBride is representing, but I can't comment on what this court will think of that evidence. But it's the state's decision to present 3 different DNA reports, at least at the current time, according to the memo that they gave us earlier this month. And it's their federal law enforcement partners who have not complied with that reasonableness test. And that's got to be imputed to the prosecution because we don't have it. Nobody's accusing anybody seated at counsel table or over there of stalling out anything. And I think the court deserves to know why the FBI and the ATF haven't turned over these data files.
Well, I mean, I understand, but that doesn't get us to where we are today. The why doesn't help us right now.
Well, the
because-
why might tell us when. I mean, Your Honor is absolutely right. The better question is when. And then when we get them and our experts look at them, maybe there is a refined assessment about how long that takes.
So my
Which-
final, oh, I'm sorry.
No,
keep
no.
going. My
That's all.
final question is I'm trying to avoid a slippery slope of, wait, we need one more thing, we need one more thing, we need one more thing. Are you saying, my understanding is, and I have, I understand to a small degree, given my experience about what you're requesting. You're requesting the lab notes, like all the underlying data that was put in to generate the DNA reports and the findings. Is that my understanding? What you're requesting is that is still outstanding?
What is actually outstanding is, yes, but most importantly, the data, the electronic quantification, digitization of physical evidence taken from our client and certain objects that leads these forensic examiners to conclude that there are matches. Mr. McBride says, oh, there's 2 different things, and so they're both right because they each independently reach the same conclusion, but they're testing different objects in different labs with different protocols. We don't even have those data. And yes, with respect to, the court may be asking me a question that is better addressed by Mr. Burt because he's the one who specifically crafted the discovery request. And I know that Mr. Burt has reviewed more of the DNA forensic discovery than I have, but I can tell the court that without those data files, we can't even start to analyze, to understand, to appreciate the conclusions, the statistical analyses, the results of those tests. So yeah, the bench notes and the protocols that were followed, yeah, that's all important, but we don't even have the data files. And there's no reason that I am aware of that has been provided why the ATF and the FBI, first of all, the ATF, why they provided it in the last 3 weeks, and why the FBI still hasn't. And so I don't think it's going to be a dribble of this and that and this and that. It should have all been produced, some of it 6 months ago, because we have DNA reports from September of 2025 that Mr. Gray relied upon for his information.
I guess what I'm trying to do is I want a bright line of saying, this is exactly what we're requesting, and it's the court's decision if that's necessary or needed to proceed with a preliminary hearing. I just want it to be so clear that we know, okay, it is, hypothetical, we need a blue pen that is Bic or whatever, that is so definitive there is no question, because what I'm trying to avoid is, well, okay, they provided this, but it's not exactly it. They provided this, is not exactly it. And I respect your position, and I understand it. I just want to make sure there's no ambiguity. And that's why I'm trying to distill this to its finest point, so I know exactly what you're asking. Because when you say data files can be anything. I want it to be clear as day, so nobody can say, well, I didn't realize it was that. And you're saying the FBI hasn't turned over the data files, that is a very broad statement. And so I want to make sure we distill it to, it is this exactly. So the prosecution can say, okay, well, if we need to communicate with our their federal partners, then they can, and they can say, this is what we needed. But if it's just a broad, we're missing data files, that's difficult for the court to weigh whether it is actually necessary in order for the preliminary hearing to proceed.
So I think then what the court is maybe requesting or maybe suggesting is that there's going to be a continuum from what data we need in order to be constitutionally effective at this prelim versus the continuum from that all the way over to what is more in the nature of expert notice, 702 Daubert issues before a trial. And as long as the state's position is none of what you're requesting, not even the digitization of the DNA taken from Mr. Robinson and the DNA lifted from these objects, if the state's position is that that's just Daubert discovery, then we can have the conversation with the court, and we can give the court our view of where the line is between what is data that should be reasonably available to us now versus what is Daubert. But Mr. McBride's position is we don't even need the digitization of the DNA swabs in order for this preliminary hearing to go forward. So if the court, I'm not trying to obviously put words in the court's mouth, but if the court's saying, I'm not going to go that far, but I need to draw a line somewhere, then we can take our discovery letter, which we gave Mr. McBride, and we can tell the court, these are the things that we think we need in order to be able to go forward in the preliminary hearing, and we acknowledge that these other things are more akin to expert notice, Daubert, and Rule 702 issues. We can do that, and it wouldn't take long, but and I think it's an appropriate way for the court to say, I'm not able to guarantee Mr. Robinson effective assistance of counsel at a preliminary hearing until the defense has these pieces, and the others can wait. So I understand the court's question, but it does require looking at a 3 or 4 page discovery letter and drawing a line somewhere. Or maybe it's yes, no, yes, no, yes, no, or, you know what I'm saying.
No, but to be quite blunt, that was the hope of the court for today. You're asking for the continuous because some discovery hasn't been provided, but I want to know what that is in order for the court to weigh that.
Well, we will do that today. We'll do it the moment the court wants to take a break. We can do that.
Okay.
And we can tell the court, these are the things that we think that all the different authorities that I've cited require now versus the things that Mr. McBride is saying are expert discovery. And then the court will make its determination of which bucket each of those items goes in.
Sure, I appreciate that.
I think that's fantastic.
All right, thank you, Mr. Novak. I think I've asked plenty of questions. I want to afford the other side the opportunity.
Always open to questions, Your Honor.
To have that same experience. All right. All right, turning to the state. All right, so the defense has emphasized that this is a capital case which triggers an Eighth Amendment requirement for heightened standard of reliability at all critical stages of the proceeding. How does the state's proposal to proceed with highly technical, uncross-examinable forensic hearsay reports without defense having access to the underlying data, I use that word loosely, satisfied this heightened constitutional requirement and the defendant's Sixth Amendment right to effective assistance of counsel?
Well, my tendency is to say, well, if you require these experts to come in and testify, we're doing the same thing that happened in Lopez, that was rejected by Lopez in obviating the admissibility of reliable hearsay. And I don't think that just because it's a capital case, you throw, the baby out with the bathwater here. The rules are the rules, and they satisfy constitutional muster, and they don't change because it's a capital case. Should we pay special attention to them? Absolutely, we should. And we should keep in mind what's at stake here. But it doesn't mean there's a completely separate set of processes and rules that apply to a capital case, right? It's just that we are very rigorous in the analysis of how we apply those same rules to these facts. So I think reliable hearsay is still admissible, and that's where we are. The rules govern, and the rules clearly don't require expert discovery and expert notice before the preliminary hearing. I don't think there's any way to read the rules to require that.
All right. One of the other issues that's been brought up is defense argues that the FBI and ATF act as your law enforcement partners and therefore are part of the prosecution team. How do you reconcile your position that you only need to provide what is physically present and reasonably available to the prosecutor under Rule 16A2 with the broader definition of the prosecution team? Does the state have an affirmative obligation to compel its federal partners to produce the underlying forensic data for this hearing?
I don't think for this hearing. I think the state does have an obligation, absolutely. I think that obligation, the case law is very clear, that obligation certainly applies by trial, right? We've seen numerous cases reversed because the prosecutor has not gone out and gotten material that's in the possession of a law enforcement officer. Some of that stuff, the prosecution probably couldn't have gotten anyway because it was hidden by police officers, right? But yeah, certainly by trial, the defense is entitled to all this material. I can't say all of it because there's probably going to be some objections to some of the material they've requested, like the source code for some of the proprietary software developed in this case or used in this case. But they're entitled to most of that stuff, and we're going to provide it. And because that's the basis of 702 hearings and also admissibility under 702 and weight questions at trial. But at the preliminary hearing stage, no. The state does not have the same obligations, the same discovery obligations that apply at trial. Now, that doesn't mean the state can put its head in the sand either. What I think is important under Rule 16 is what is reasonably available to the prosecutor. And that's what we're doing here. The point of my April 3rd filing was to say, Judge, look at our over 20,000 documents or files that we provided to the defense. You can see in there. And we asserted at that time we'd provided approximately 100% of the materials that we have, right? And you can see that we're not burying our head in the sand and saying, don't give us anything else, guys. We don't want to know. No, we're saying, give us everything. And as soon as stuff comes over, we send it out. And you can see in there the dates that we receive materials and the dates that we push them out. And we're talking within a week, generally speaking. Sometimes within days, no longer than probably 2 weeks. We're pushing everything out that we get. And so what is reasonably available to the prosecutor, what does the prosecutor have in his possession, those are the materials that we've provided, and we've satisfied Rule 16. What we can't do is bury our head in the sand and say, don't give us anything else. And that has not been what's happening here. But neither do the rules require complete expert discovery and discovery of these highly technical data files. And that, your line of inquiry with Mr. Novak just a minute ago raises the importance of this. Yes, the defense, I can't tell you the first date that we had a conversation, an oral conversation, where they said, hey, we need the data files. And I remember a conversation we had, I can't remember, Mr. Burt, if it was with you or Mr. Novak, and I said, well, look, assume I'm an idiot. I don't understand what data files are. Tell me exactly what you need. And they say, well, we need the software files that can be used in the software program so our experts can run it. Okay, put that in writing so I understand and don't misrepresent what you want. And so when did they put it in writing? March 25th. So once I got it in writing, that's when we started looking through. I looked through my file and analyzed, do we have this stuff? Have we provided it? Help me understand what's going on. And after I did my analysis, I sent it off to the labs and said, hey, I've done my analysis of what I think we've provided here. Will you guys look at this and see what you think you've provided? And then tell me if if you haven't, get it to me. If you're not going to, tell me why. And we had that communication, we had a communication about that this week with both ATF and FBI. And I think a lot of this material they've requested, we have provided it. Some of this material was provided clear back in October, most of it. A 380-page digital case file from the FBI, disclosed October 24th, debate stamp 79, CVs of 3 of the analysts from the FBI. There's case notes were provided October 24th, that's Bates 122, and Bates 845 to 848. 73 files of policies and protocols, validation, testing procedures, analysis, proficiency procedures, provided October 24th and 12 on December 9th. Now, the ATF lab, they were continuing to do investigations, or excuse me, not investigations, but expert scientific work on this case until the end of February. They chose to wait until they finished to compile all of their case files and to get them to us. We're talking thousands of documents. It takes, you don't snap your fingers and have them all together. It takes time to put them together. Once they got them together, they sent them to the SBI for processing, make sure that the detectives and investigators are aware of the materials, and they provide them to us. We bait stamp them and send them out, and those are the materials we received this week. Okay, so there's been no delay here, and we've done what's required under the rule. But I think the important point is to go back to the purpose of the preliminary hearing, because what you're talking about here is, have we completed full expert notice? I mean, I know Mr. Novak says, well, that's not what we request. Well, that's what we understand, and that's what the pleadings seem to request. And this material, these data files, those are materials covered under full expert notice, under 77-17-13, not under Rule 16, and certainly not under, there's no mention of when this material has to be provided elsewhere. So I just don't see how this is necessary for the limited purpose of the preliminary hearing, particularly in light of all the other 3 categories of evidence here. I think this is why, and Mr. Novak couldn't talk about whether or not this discovery material of expert material would affect the probable cause determination. This is why the Lopez analysis is so important, is because you can hear the evidence, you can listen to it, and you can say, you know, there's the confessions, there's the circumstantial evidence, there's the video evidence, and then there's the DNA evidence. I don't even need to consider the DNA evidence, and there's probable cause here. And that's the state's position, is that there's probable cause regardless, and there's no showing the defense can make that would say it's going to undermine probable cause here. That whatever their experts say, best case scenario for the defense is they get an expert that says both labs messed up. It doesn't affect probable cause because you weigh the evidence in the light most favorable to the state with relation to the DNA evidence, and there's all this other evidence anyway, a confession. That's clearly probable cause. So I would ask the court to hold off, deny the motion for now, hear the preliminary hearing evidence, and then let the defense make their showing. And if they can make a showing that undermines probable cause, fine, give them their continuance. And at the same time, have them tell us exactly what data files they're talking about here, because that's exactly what I asked for, and they gave it to me on March 24th, less than a month ago. So that's the process I think you should follow. And, you know, I know the other thing the defense has said is, well, look, the state doesn't have to use this evidence. They're right, we don't have to use the evidence, but we're not going to not use it where the rules allow it. We're not going to back down because of an argument that's meritless in our view. We're entitled to use it, we're going to use it. If the court decides not to rely on it, that's fine. You know, so that's my position on that, Your Honor.
Final question, and I appreciate both sides in their presentations. Is there a reason that you recognize that the defense would be entitled to a continuance?
Well, I think there's 2 components to that in my mind. First is, you know, in a lot of cases, we will stipulate to a continuance, you know, out of professionalism, preparation. You know, there's a lot of things that we stipulate to continuances on. But generally, we're talking a 2-week, you know, maybe a month continuance. Here, this is a significant continuance that we think violates the victim's right to a speedy trial and affects our ability to get justice in the case. But the second component is why, yes, we would absolutely stipulate to a continuance under some circumstances. This case, it's hard to say because there's these 4 different categories of evidence that I've told you about. And the failure of any one doesn't mean the rest fail, right? Each one of these categories of evidence really establishes probable cause on their own. So it's hard to say why we would agree to a continuance in this case. You know, I mean, I'm thinking of a recent case I had where defense counsel's father died right before a trial. I stipulated the continuance, okay? Something like that happens, of course, we're going to extend that professional courtesy to the defense. You know, as it relates to preparation, I don't think the defense needs to, and this kind of goes to your question to defense counsel, hey, are you going to render effective assistance? And I'm thinking, you know, if I were in your shoes and they say they need more time to be prepared, yeah, that's a legitimate concern. And would I would I agree to a continuance for them to be prepared? Under certain conditions, absolutely, you know. For example, let's say they hadn't reviewed the 35 exhibits we're going to present, right? We've narrowed it down, you know, given greater notice than is required by the expert notice statute, in fact. You know, more than a month's notice of all the exhibits and witnesses we're going to call. There's 6 witnesses we're going to call. There's about 35 exhibits we're going to provide. Most of those exhibits were provided to them clear back in 2025. The last one I think was provided maybe, I've got it on a list here, but I know you have it in that letter I sent, Mr. Novak, but the last one was provided there's a tool marks report that was provided March 12th, okay? So under these circumstances, no, they can review these 35 exhibits. We've got plenty of time to review them. I'm sure between all of them, they've reviewed all these exhibits. They're the DNA reports, there's photos of the rifle found, photos of the rounds in the rifle, surveillance video of the defendant on the scene, video of the shooting itself from people in the crowd, medical examiner's report, doorbell camera video of the defendant approaching in his car. The defense has all this. They can be prepared on time. So yes, there are circumstances, but I don't see them in this case.
Thank you.
Your Honor, may I go back to the request that the court made for a little more clarity? Exhibit F to our motion is Mr. Burt's discovery letter, which Mr. McBride and I have both been speaking about. And Mr. Burt is prepared right now to tell the court which pieces of the discovery letter we view as core discovery that we're entitled to before the state offers any DNA evidence at the prelim, and which pieces of that discovery letter are more in the nature of expert notice under Daubert. So if the court wants to hear from Mr. Burt right now, we don't have to delay that, but I want the court to understand that Exhibit F is probably the template for that.
All right, and I'm happy to hear from Mr. Burt. Is more time needed, Mr. Novak, to confer on to my first question about the discovery that's been reviewed?
Yes, I think that would have to happen during a short break.
Would a 15-minute break help accomplish that?
Very much so, and I'm sure others would appreciate it.
All right, well, let's turn to Mr. Burt, and then the court will take a 15-minute break, recess. Mr. Burt.
So, Judge, to simplify a pretty complicated issue, this DNA testing, it's a black box technology. That technician processes a sample, puts it into a genetic analyzer, and what he gets is electropharogram, these little squiggly lines. I'm sure the court's familiar with that. But the machine that they put the sample into generates internal electronic files. And when the FBI or the ATF analyzes the samples, they can adjust the parameters to decide how low of a level do they want to look at the sample. And they have set standards. If it falls below a certain level, they don't want to look at it. That's just the way they do it. And in this case, what you have on all the samples, they're what are called complex mixtures, up to 5 people in each of the samples. So when they have that kind of a situation, then they use another software program called STR-Mix. And they run this program, which also has internal files. And that program supposedly sorts out whether various people can be identified with a sample. So of the information we requested initially, way back on September 16th, we requested all electronic files. And in dealing with the FBI and the ATF for many years, when you make a discovery for electronic files, they know, Mr. McBride might not know, but the FBI and the ATF knows that what you're talking about when you're asking for electronic files is the machine output that can be used by another expert to reconfigure where the DNA readings are taking place. And they can only do that when they have the underlying electronic data from the genetic analyzer. So the FBI was given our initial discovery request, and I don't know, I've done probably 100 cases with either the FBI or the ATF, and when you ask for electronic discovery, you get two things. You get the case file, and that contains all the underlying notes of the analyst who is processing the scene. You get the electropherograms, which are the little squiggly things, and you typically get a disk with the electronic files on them. Those files cannot be read by lawyers. It requires software that lawyers typically can't afford, $10,000, $20,000 for the software packages, but they can be analyzed by the experts, and that's the information that we're asking for here. And so it's not correct that we didn't ask for this stuff in the beginning. We did. We did have a subsequent discussion where Mr. McBride said, I'm unclear on what electronic files mean. And so I did provide in a letter specifying exactly by file extension names exactly what that meant. And in the discovery letter we sent to him, to answer the court's question of what's essential here, item number 6, data files, please provide copies of all computer data files created in the course of performing the testing. And then it specifies both raw data and processed data. These files should include all sample files, FSA and or HID files, matrix files, standard files. Any DNA expert would look at that and know exactly what we're asking for. And again, it's standard. It's all it is pressing a button. They can put that on a disk and give it to you within the day. But for some reason, it wasn't provided. And so that's item 6. That's essential information. And the second essential piece of information in this discovery letter is item 9, the STR mixed data. And under that category, we've listed 6 elements of the electronic data related to the XTR mix. The rest of the discovery requests are broader in scope, and as you were told, that's going to be worked out. But the 2 key elements that we don't have are 6 and 8, or 6 and 9 in this discovery letter. If we had that information, we could get it to the experts. The experts could look at it, see how complicated it is, give you better estimates how long it would take to put together their analysis. And their analysis, we have to depend on them because we don't have the expertise or the software to be able to read these data files.
So, and I appreciate that clarity. That's exactly what I was looking for. My next question is, let's hypothetically assume, and the court is not trying to indicate any direction.
Sure.
But let's hypothetically assume I say that's not necessary to move forward at the prelim. Is your expert ready to testify?
Ready to testify at the prelim?
Yes.
The expert would be prepared to come in and explain to the court what they could opine based on the information they have, but the bottom line of the opinions would be what they stated in their declarations to the court. Without the underlying data, it's impossible to draw conclusions. Part of it, the issue here, the specific issue is the STR mixed data that we're asking for includes the internal validation records. The internal validation records tells the lab how many people in a mixture they can reliably assess using this software. And we cited some cases to the court in the continuance motion where courts around the country are struggling with this issue. There's a certain number, if you surpass, that you can't reliably sort out a mixture. So the experts would come in and tell the court that, but they'd also say, till I see the internal validation files, the underlying data files, I wouldn't be able to tell the court whether they can reliably sort out these mixtures or not, because I haven't looked at what their files say.
So, and I appreciate that, but my question is, have you received the lab notes I understand, it sounds like in order to simplify it, there's some internal settings for these machines, calibrations and such.
Right.
That is separate than lab notes where.
Right.
Now, I just want to make sure I'm on understanding. Have you received the lab notes for the DNA that the state is intending to move forward on as they've given you notice? Have you received that data?
We've received the case file, the lab notes, I'll call them, from the FBI, not the ATF. So we're missing the ATF lab notes. We do have the FBI lab notes, but those lab notes will tell you how the sample was processed up to the point when it was put into the machine. It will not tell you anything about whether the machine reliably spit out the number of contributors in the sample, or how they sorted out, how they're matching one of the 5 or 6 people in each sample to Mr. Robinson. That's where we're lacking the information. So I can, and have reviewed the lab note files that tells me how they process the sample. But the critical issue here is, can they reliably sort this out given the complex mixture that they're dealing with? And so that question cannot be answered based on the information that we have and we reviewed.
Thank you, Mr. Root. I appreciate that.
Thank you.
It provides a lot of clarity. All right, let's go ahead, and we're at the 12 o'clock hour. Let's break for 15 minutes, come back at 12:15 to confer with defense in regards to discovery, and then we're going to transition to talking about the media in the courtroom. As indicated, it's not the court's intent to issue a ruling about continuing the preliminary hearing. I want to weigh the evidence, the oral argument, the information today, but I am also cognizant of the timelines, and so that ruling will not be delayed because both parties require that, as they should. With that, court is now in recess.
All right.
Here's the little room, you know, the juvenile room.
So is he breaking the law?
This is for us to tell them how we're not